Good morning, good evening, good afternoon, wherever you are. Welcome to this program that we think is going to be very special, Deals and Disputes, China, Hong Kong, and Commercial Law. My name is Ron Brand. I am a law professor at the University of Pittsburgh, where I'm also director of our Center for International Legal Education, CILE. At CILE this year, we're celebrating our 25th anniversary of the creation of the center. And this program is a part of that celebration. It is the final monthly program over the academic year in celebration of our 25th anniversary. And we are celebrating by joining with the Asian Studies Center, part of the University Center for International Studies at the University of Pittsburgh, a center and the package of centers within USIS really make it possible for all of us in the university to engage in global matters in a productive way that is very special, and this event is part of that. So I want to welcome you and hope that you'll join us for all 3 days of this very special program on an important topic. I want to begin this morning by welcoming Ariel Armani. Dr. Armani is the Vice Provost for Global Affairs, as well as the Director of the University Center for International Studies here at the University of Pittsburgh. Ariel, welcome.
Thank you, Ron. Thank you so much. It's great to be here and to be with all of you for this very, very interesting and important conference. So dear invited guests and Dean Wildermuth, on behalf of the University of Pittsburgh and the University Center for International Studies, I want to welcome you to our 3-day conference on Deals and Disputes, China, Hong Kong, and Commercial Law. Since 2013, China has adopted its Belt and Road Initiative as a platform to increasing its international standing and influence. It is now the centerpiece of Chairman Xi Jinping's foreign policy. Most research on the initiative has focused on China's rapid expansion of infrastructure construction projects. To date, the initiative has funded hundreds of projects in Central Asia, Eastern Europe, Southeast Asia, Africa, and Latin America at a cost of $50 to $100 billion per year. The initiative, however, is not limited to just infrastructure development. It also has critically important soft power aspects, including education, think tanks, and the influencing of international norms. This conference, sponsored by Pitt Law's Center for International Legal Education and the Asian Studies Center, builds upon previous research by both centers on China's evolving relationship with international law. As we shall see, China has been active in promoting legal theory and process that is more amenable to its vision of international relations. Furthermore, part of our focus must include Hong Kong, as that city's role as a center for commercial activities evolves under CCP control. It is important to assess how it too will become another avenue for China to influence the practice and conduct of international commercial law. The program schedule includes renowned experts who have worked on China's commercial law role for decades. The 3 panels and 2 keynote talks will explore commercial law, dispute resolution, international arbitration and litigation, and Hong Kong's role as a center for these activities. I'm sure it will be a very, very productive conference. The University of Pittsburgh School of Law and the University Center for International Studies are leaders in the study of the practice of law and the study of global affairs. Outside of the Asian Studies Center, UCIS, the University Center for International Studies, hosts 5 other area studies centers. Our Asian Studies Center is a U.S. Department of Education National Resource Center, a designation provided only to the leading centers in the field, and hosts dozens of talks, conferences, and community development programs every year. NRC funding is supporting the conference, and I want to thank the Department of Education for its support. Recently, the center hosted a conference analyzing China's infrastructure activities in Latin America with experts from 7 countries participating. Collected essays from that conference will appear in a publication in the near future. The Center for International Legal Education operates both within the School of Law and as part of the University Center for International Studies. As Professor Brandt said, this program marks the final event in a year of celebration of CILI's 25th anniversary. The Center for International Legal Education provides international and comparative law opportunities for Pitt Law students and faculty, and hosts students, visiting scholars, and visiting professors. It's an active part of cooperation with law faculties in transition countries throughout the world, helping develop law school curricula and expertise as a leader in international legal education. So on behalf of UCIS and the entire University of Pittsburgh, I welcome you to this very special event. Thank you.
Thank you, Ariel. Now we welcome Dean Amy Wildermuth from the School of Law.
Thank you for Professor Brand, and thank you, Vice Provost Armony. It is my pleasure on behalf of the University of Pittsburgh School of Law and our Center for International Legal Education, or as we like to call it, CILI, to welcome you, our many participants, as well as our distinguished guests and speakers who are joining us from around the world to this conference, which highlights the interdisciplinary cooperation that is possible here at the University of Pittsburgh through UCIS. The Asian Studies Center within UCIS and Pitt's CILI regularly cooperate on programs benefiting our students. And this program, as you already have heard, is truly special in highlighting current developments in China, Hong Kong, and Asia that impact commercial law, dispute resolution, and fundamental questions of the rule of law, all areas in which our law school has played an important role. You have already heard that this is the final event in a year of very special programming highlighting the 25th anniversary of CILI. And of course, CILI has hosted students from around the world for our LLM and SJD programs. In fact, we are very proud that one alumna of both of those degrees recently became president in her home country. Others have taken leading roles in academia, government, international organizations, and private practice. CILI has also provided opportunities for hundreds of Pitt Law JD students to engage directly in the study and practice of law throughout the world. We are particularly proud of the role CILI has had in working with law schools in transition countries to develop new courses, train students and professors for a global role in international commercial law and arbitration through the VIS International Commercial Arbitration Move, and work with the U.S. Departments of State and Commerce to advance legal education and the rule of law in those countries. CILI has also played an important role in programs for the legal profession generally, and this conference is a fitting example of that role. The keynote speakers and panelists for this conference bring a wealth of expertise and experience to the issues they will discuss. I want to express my gratitude on behalf of the School of Law for their role in sharing their insights, on matters that are vital to the legal, economic, and political future, not only of the Asian region, but of the world. So again, on behalf of the University of Pittsburgh School of Law, I warmly welcome you and wish you well over the next 3 days of this special event. Thank you.
Thank you, Dean Wildermuth. Good morning, everyone, and good evening, good afternoon. My name is James Cook. I'm the Associate Director of the Asian Studies Center at the University of Pittsburgh. And on behalf of the Asian Studies Center, I want to welcome all of you to our 3-day conference on deals and disputes. It is my privilege today to introduce our first keynote speaker, Professor Susan Finder, who is currently Distinguished Scholar in Residence at the Peking University School of Transnational Law. Professor Finder is a renowned scholar of China's judicial system, and her current research concentrates on the Supreme People's Court and Chinese judicial reforms. Much of this can also be found on her blog, The Supreme People's Court Monitor. This is Professor Finder's second career in academia, after spending 20 years in China-related practice at Freshfields, Brookhouse, Derringer, and other firms in legal publishing and as a securities regulator. In her first academic career, that is now what is the City University of Hong Kong, she published the first comprehensive study of the operations of the Supreme People's Court. Professor Finder received her undergraduate degree from Yale University, her JD from Harvard Law School, and a Master's of Laws degree from Columbia University. Today, we warmly welcome her to give her talk on the Supreme People's Court and the development of Chinese international commercial law. Professor, please. Oh, we have you muted.
Oh, sorry. Yeah, thank you very much. Let me start. Hold on. Wait a minute. Oh, wait, sorry. And okay. Yes. So what I'll talk about is how the Supreme People's Court makes an important contribution to Chinese international commercial law. This is meant broadly, as I'll explain in a minute. So the background, as I think everyone knows, it's a shift in China's foreign policy. China is seeking to assert a greater global leadership role, more robust. So part of that is a more robust role for China's judiciary. You can see that most in maritime matters, now in intellectual property and antitrust matters. As seen from China, the courts are the indispensably important force for ensuring the legal construction of the Belton Road. This is by the former vice president of the Supreme People's Court. So what he's saying is the courts are critical for ensuring, from a legal point of view, that the Belton Road is a success. So my presentation will explain, what the Supreme People's Court does and a bit of how it does it. Yeah, so invisible, this is the cloak of invisibility. So in my view, it's an invisible, but it's an important topic. So this list isn't complete, but the Supreme People's Court develops what I call international commercial law in several ways. So hearing and deciding cases, and thereby creating a body of case law. Second, I'll explain a little bit about, it's not an, Anglo-American system. I'll say a bit about Chinese case law, making judicial policy, issuing quasi-legislation and court rules. I'll say a bit about new internal institutions, including the China International Commercial Court, and what I call firmly supporting other government institutions. So I'll say a little bit about the Supreme People's Court working together with other government institutions. So the background in China is Chinese legislation is kind of insufficient for use. It's often lags far behind. The arbitration law would be one example. And it's not detailed enough. So it's the practice that has arose over several decades is the Supreme People's Court does a lot to fill in the gaps. Yeah, so here's my roadmap. Yeah, so I'll give a bit of background, and then the other sections are as I just mentioned. Yeah, so 6 parts. Yeah, so in the background, some definitions and statistics, some generalizations about the role of the courts in the Chinese system, a bit about commercial activity, and then a bit introduction to the Supreme People's Court. Yeah, so what do I mean by international commercial law? Law, I mean, is just a range of legal norms, not in the technical sense that is meant in China, which of being national law. International, also not in the technical sense, so including disputes from jurisdictions outside of mainland China. So that would include disputes with parties in Hong Kong or Macau, etc. And I'm also bringing in which disputes that under Chinese law aren't international disputes, but if they are for the purposes of my presentation, which is domestic disputes related to a commercial transaction outside of China. There are quite a few of these. So China does a lot of engineering projects outside of China. When the project owner wants to call the performance guarantee, oftentimes there's litigation in China where the construction company tries to prevent its bank from paying on the guarantee. There are also, some of the deals are done by a shareholders dispute, a shareholders agreement in China, as disputes arise there. And then there are a number of other domestic disputes, but related to a deal outside of China. Yeah, so some background on the number of cases. Yeah, so it's this graph of the number of cases accepted by the Chinese courts from 2004, yeah, so about 9 million up to now, so up to last year, so about 30 million. Yeah, the big change was 2015 when the government changed the filing system for cases. So you can see there's an enormous increase. So all my statistics here are from this year's NPC, National People's Congress. So the report by the Supreme People's Court to the National People's Congress. Okay, so you saw the 30 million number. So this is the number of nationwide first instance foreign related no, I think it's not civil cases. I think it's just foreign related cases in the Chinese courts. So this is without Taiwan, Hong Kong, etc. So my point is it's only in the range of about 22,000. If you include Hong Kong, Macau, etc., I would guess it's about the same number or slightly more. So anyway, we were talking in the range of about 50,000 cases in the Chinese courts involve a foreign, a party from outside of China. Yeah, so this is foreign related IP cases. Yeah, so yeah, so about less than 10,000, so also really small. So this illustrates, so this is a very famous saying in China, you know, 歪事无小事. So no matters are small in foreign affairs, or so even though it's a relatively small number of foreign related cases in the Chinese courts, because they involve foreign affairs, their importance is much greater. Okay, so a number of generalizations about the courts in the Chinese system. So the Chinese Constitution says the Supreme People's Court is the highest judicial organ. So what I would, for this talk, I'll pull from that, the term jiguan or organ. It kind of symbolizes that the Supreme People's Court operates as a cross between a bureaucracy and a court, and therefore has commonalities and differences with other central level organs, you know, or institutions. As a court, it has common and unique functions as compared with civil and common law courts abroad, as you'll see. And then, as I'll explain later, it enjoys a firmly cooperative relationship with other central organs. So I mean, it's a complicated question. I'll just highlight a little tiny bit. Okay, so what's the background again? As I've said, so Chinese companies are doing a lot of things overseas. So a lot of Chinese companies are doing a lot of construction contracting. Yeah, so many cases, investment, all sorts of projects offshore, and even some involve Chinese individuals traveling, etc., abroad. Okay, let me see. Yeah, so this is, you know, I thought it's better if I have a photo so everybody sees what the building looks, or at least one of the buildings looks like. Yeah, I mean, it has a number of buildings, but this is the main one. Yeah, so this is a piece of what is a bureaucracy. This is the internal organization chart. So it's taken from the Supreme People's Court's English website. For some reason, the Supreme People's Court IP court got left off. The China International Commercial Court isn't on here, but it's linked to Civil Tribunal number 4. So there's a case filing tribunal. So there for criminal, well, yeah, anyway, I should just focus on, yes, you can see the big bureaucracy. The green offices are mostly ones that are found in other central organs, but not entirely. Yeah, then there's, okay, let me, yeah, so for my presentation, the number 4 civil tribunal or division, it focuses on international commercial or maritime issues. the China International Commercial Court, which has been around since the middle of 2018. The number 3 civil tribunal or division that focuses on IP, and then there's the Supreme People's Court IP Court. I think it went into operation the beginning of 2018 and takes certain IP cases. Yeah, so for the purpose of my talk, the relevant jurisdiction of the SPC, so appeals reduced in 2019 by rules raising the amount of dispute, but that doesn't apply to the IP court. So the IP court is meant to take a lot of IP issues from the lower courts in appeal. Judicial supervision or retrial. China has a one appeal system. So judicial review of arbitration matters. This is really important practically. It reviewed about 300 in 2019. Almost no first instance cases. Yeah, so here are some statistics. Yeah, so for last year, about close to 40,000 cases were heard by the Supreme People's Court. What the exact breakdown by area of law is unclear. Because the Supreme People's Court, like the number of death penalty cases, that's a state secret. So they're careful to leave the statistics general. So it's not, the number of death penalty cases is not apparent. But what I could see, most appeals are heard in the IP courts. There are many what are called applications for retrial, and the majority of cases are heard in the Sixth Circuit courts located around China. Oops, sorry. Yeah, so a bit about decision-making process reforms. Applicable to all levels of Chinese courts, but to this SPC as well. So giving more autonomy for 3-judge panels. In the old system, basically all cases need to be signed off by the head of your tribunal or division. They have this new professional judges meeting where difficult cases are discussed, and there's something called in the Chinese courts a judicial committee, the committee of senior leaders. It seems fewer cases are going there. Yeah, so one of the reforms is this official database with millions of cases. I mean, there's academic research. There certainly are cases, sensitive cases are missing, but it still means a huge amount of cases are available. So for somebody like me who's been in the business for 30 years, it's amazing. Yeah, some translations are available. Yeah, so a bit about case guidance. These guiding cases are kind of semi-binding. All the rest that I've listed here are soft precedents, and they can't be cited in judgments. The guiding cases can. Those need to go through an approval process by the Supreme People's Court. So there are these typical cases. Yeah, so judicial review arbitration cases are very important in the area of commercial arbitration law. So the CICC decisions that have been made tend to be quite important because they are taking cases where they can address issues of law where the law has been unclear. Also, decisions by the Supreme People's Court are are significant, but okay. Yeah, so for IP law, it's similar, although for decisions of the IP court, and they have these summaries of decision, those are also very important. So they have an impact on the lower courts, lawyers, and in-house counsel. So for the lower courts, if the law and what is called judicial interpretations are unclear, then they'll look to these soft precedents. They need to decide cases correctly. So these they know are the best answer. Okay, so a third major function of the Supreme People's Court is making judicial policy. It's a enormous focus for the Supreme People's Court in the Xi Jinping era. So a lot of them support evolving party policy, including Belton Road and other. So these judicial policy documents are challenging to decode, at least for somebody like me, because of there's a lot of party jargon, and there's a lot of there are words, but then you need to, I finally understood there's for each phrase or for each sentence, there's often a related issues, related policy documents, but it's tough, it's really tough for the amateur to try to figure these out. Yeah, so I've listed 3 of the most important policy documents related to international commercial law. So there's a 2015 one on providing services and guarantees to the Belton Road, a 2019 one on providing further services and guarantees to the Belton Road, and there's a 2021 a guiding opinion on the open policy. So what are the purposes, what are these documents doing? They notify the court system of many court system and other people in government and outside government. There's going to be a change of judicial policy. So related to a change of government or party policy. Something is a new issue of concern, or the issue has evolved slightly. It will also flag new items on the legal developments agenda. That it'll say, oh, we're explore looking at this, or sometimes there's language that's quite clear that the Supreme People's Court is going to look to issue a judicial interpretation on something. So there's a lot of content in there. I mean, you could see this in my blog, but it's hard to figure out at first reading. So before going on to new institutions, so I'll say a bit about 2 of them. So one is the China International Commercial Court, about which there's, I think, many, more academic articles than the court has taken cases. So established from July 2018. In my view, it wasn't approved as a new institution within the SBC. So it's not there with its own little as being a separate entity. And it doesn't seem to have brought with it, a separate headcount, because all the judges are doing CICC cases on top of their own cases. But under Chinese law, all judges must be Chinese citizens. So because China wanted to come up with its own international commercial court, they came up with the idea of an expert committee with foreign, Hong Kong, Macau, Taiwan, and domestic members. I mean, I happen to be on this expert committee, but nothing in this presentation should be linked to either the CICC or the Supreme. Now, I'm speaking for myself as an academic, and it shouldn't be attributed to the Supreme People's Court or the CICC. By Chinese law standards, there's some innovations in the rules of the CICC. The drafters needed to work within the rigidities of the civil procedure law, but they borrowed some ideas from international arbitration law, and some other ideas from other international commercial courts. So they looked to arbitration, looked elsewhere in the world to see what ideas they could bring in that would work in the Chinese environment. Yes, so yeah, one of the things is accepting evidence in English unless the respondent or the defendant objects, and some other procedural matters. The CICC has issued a small number of decisions, either judgments or rulings on arbitration-related matters. So in the region of a dozen, and they all address points that weren't addressed well by statutory law or judicial interpretations. So generally they've been hearing cases in 5-judge panels, which means it's an important matter. Yeah, and you get there. I think you can watch their cases on the Supreme People's Court video library. Yeah, so this is the Supreme People's Court IP court. Yeah, so it has its own building. Yeah, so which I visited, but that's neither here nor there. Way far, like the far southeast, southwest, I think southwest of Beijing. Yeah, so that the IP court has about 40 judges working there full time. So they've decided over 5,000 cases in the last 2 years. Yes, they have their own case law, including judgment digests. I think of those 5,000 cases, about 400 are, for either involved foreign parties or Hong Kong parties or Macau parties. But their jurisdiction is limited, I think, patent and others, a number of technical matters. Yeah, so this quasi legislation is extremely important in China. Yeah, so make some comments, flag their legal basis and authority, and then give a few examples. Yeah. Yeah, so these judicial interpretations range across the spectrum of Chinese law. So there's many in the criminal law area. There's all sorts of civil law issues. And they're issuing many to accompany the new civil code. Let me environmental law. So whatever area of law the Supreme People's Court hears or the lower courts hear, there's generally a related judicial interpretation. So it has to do with what I said earlier, legislation being not detailed enough and often not a bit back, behind. There's a lot of criticism of these interpretations by Chinese academics and even some academics outside of China for the Supreme People's Court making law. And kind of going asserting authority that they think should be exercised by the legislature. Sometimes legal professionals, discuss a new interpretation as, disagree with it. Sometimes publicly controversial. That generally more happens in the area of interpretations related to, like, the old, like the marriage law and distribution of marital property, or so like attributing debts incurred by one spouse to the other, and other, those kinds of issues tend to be controversial among the Chinese public. So if you took a look at an interpretation, it appears analogous to legislation. It's, Article 1, Article 2. I have a book with the new interpretation of the criminal procedure law. It's longer than the law itself, 665 articles. So it looks like legislation, but actually it crystallizes legal rules from prior cases, or I would say sometimes legal rules they can foresee, or that's more true, like with the civil code, where they could foresee that some question would frequently arise. Enormously important in practice. So, if you're a Chinese lawyer or, in-house, etc., you will look to these judicial interpretations to fill in the gaps in the law. So why are they issued? Now, the Chinese courts are super busy, as I said. Chinese legislation lags behind, and not enough definitions, not enough specifics, and the legislature doesn't meet that often. So what's the basis? China has legislation law saying the interpretations issued by the Supreme People's Court and the Supreme People's Procuratorate, which is, it's more than the state prosecutor that has other oversight functions. But anyway, their interpretations on the specific application of the law during, adjudication shall mainly focus on specific legal provisions and be consistent with legislative purposes, principles, and intent. So what is their authority? This is kind of it's not enormously clear. The Supreme People's Court issued regulations on these, interpretation work. It says they're legally binding. So I have the Chinese here. The judicial interpretations issued by the Supreme People's Court have the force of law. But they're the ones saying it. It's not the legislature, which is superior to it. The interpretations can be cited in judgments along with law, and they need to be registered with the MPC Standing Committee, so that the Standing Committee could refuse to register one. They could review them and void them. If you look at the blog NPC Observer, there's one instance of the MPC reviewing one of these interpretations, but it doesn't void them. It would be, that's not the way the institutions interact with one another in China. But they're really important to lawyers in-house, et cetera, people in arbitration. Yeah, so this examples. Yeah, so this is a very important example. So the 2016, the SPC issued these provisions on the trial of independent guarantee disputes. These issued an enormous practical gap in Chinese law. And I think the big banks and the banking association put a lot of pressure on the SPC to finally get this out. This Supreme People's Court drew on the International Chamber of Commerce's rules for demand guarantees. So these independent guarantees are what are called outside of China demand guarantees. So the Supreme People's Court drew on those, drew on the UN Convention on Independent Guarantees and Standby Letters of Credit. The Supreme People's Court needed to maneuver around existing legislation to issue these, but these needed to be issued because the Chinese companies that had their demand guarantees called overseas kept on trying to going to court and trying to prevent payment on the guarantee. Yeah, so a procedural law example. So from 2017 on the judicial review of arbitration matters, the Supreme People's Court is a pro-arbitration institution. China's arbitration law is very outdated. It's from 1995, I believe. So they've been the ones to try to push, to do what they can within current law to try to modernize it. So there's a notice on centralized handling of judicial review of arbitration cases. So the idea there was to direct these cases to specialist judges, and these other two judicial interpretations were on judicial review of arbitration cases, so providing a better regulatory framework. China has this prior review of lower court arbitration-related rulings. So if a lower court wants to refuse enforcement of a New York Convention award, this potential ruling needs to be appealed up level by level from the intermediate court to the provincial high court and then up to the Supreme People's Court. And the Supreme People's Court will be the one to finally either agree to not enforce the award or to reverse the ruling that the lower court wants to make. Yeah, because when it didn't have the system in place, lower courts, probably under pressure from local business, often refused enforcement of foreign arbitral awards. Okay, so getting to so the last part of my presentation, the firm support. So a couple examples here. So one thing the Supreme People's Court does is supports other institutes. So one example is providing input on new legislation or amendments to old legislation. Yeah, so the photo here is of a Supreme People's Court conference to discuss the amendment of the Maritime Special Procedures Law. The more important one for us in commercial law is the arbitration law, which is currently, so the Ministry of Justice is working on a draft that it will send to the legislature for further amendment. So the Supreme People's Court has given its views on what it thinks should be included. But I didn't have a photo of that, so I used this photo instead. Yeah, so another aspect of the Supreme People's Court supporting other institutions is the Supreme People's Court participating in drafting or negotiating and drafting international conventions. So in the photo here, I guess, so the second from my left is Judge Xi, who participated in the drafting of the Hague Convention on the recognition and enforcement of foreign judgments that Professor Brand participated in as well, right? Yeah, so he was part, so Judge Xi was part of the Chinese delegation. So, you know, in like Chinese media, it's, you know, it just said that he contributed Chinese wisdom, right? I mean, so I am, you know, I wasn't there, but I imagine that, you know, he or the delegation had comments or suggestions in the course of the negotiation. But it's not limited to this one convention. It occurs in other areas of law as well, because they're, you know, the SP people in the SP, they're specialists, they're legal specialists. So the Ministry of Foreign Affairs that would be leading the delegation would, you know, would get somebody from the Supreme People's Court, yeah, to participate in a delegation. Okay, yeah, so I think I have like 3 more slides. Yeah, so this you would not normally see, but I thought, I don't mean this in any kind of, you know, you can see me in this photo. So this is, because one of my points is a lot of things go on behind the scenes. This was before the signing of the Singapore Convention. So the gentleman in the front in the black vest is Mr. Wen Xiantao, who from the Ministry of Commerce, who negotiated the Singapore Convention on behalf of China. So there was a lot of discussion before the signing of the convention, I think in August, of whether or not China should sign. It's a lot. It's the stories in my blog of how I got involved in this. So it was a closed-door workshop. The idea being to bring everybody together to be in the same room. So there's a lady there from the National People's Congress, but there's also, I think there's a lady there also from the Supreme People's Court. So voicing the Supreme People's, you know, the view, kind of the view of the courts about whether China should sign the convention or not. But it just so happens, you know, because of the circumstances I mentioned in my blog, I happen to be there, but a lot of such meetings take place. let's see. Yeah, so this was post-convention signing. There's another closed door workshop on on different institutions providing the views about how to implement the Singapore Convention in China. Yeah, so there's a woman there from the Supreme People's Court as well. All right. Yeah. So I mean, because I knew Mr. Wen, et cetera, and he was okay with me, for special reasons I got invited, but normally, this would happen all the time, not be open to foreigners. Some concluding thoughts. So linked to evolving party and government policy, I would expect the Chinese courts will be engaging with the outside world more robustly. They'll have a greater impact on the negotiation of international rules. They'll participate in the harmonization of Chinese law and practice with the rest of the world, or maybe not non-harmonization, harmonization like the Singapore Convention. They'll participate in creating a body of Chinese legal norms related to interactions with the rest of the world, and continue with their important role in achieving the legal aspects of government policy. So, my apologies for running over a bit. And I look forward to your questions.
Thank you very much, Professor. We deeply appreciate your talk this morning, or this evening for you. We've started to receive a few questions here, and I wanted to share them with you. Since I drew the privilege of moderating your talk, I will also impinge by asking one of the very first questions as well. And I'm going to combine this with another question received from an anonymous attendee. But in your talk, you mentioned several times about how construction contracting in the offshore areas has become a very central and very important part of the Belton Road Initiative. And that quite often, at times, demand guarantees are being made within Chinese ports for these Chinese construction activities. Now, we also know that many of these offshore construction projects are being done by some of the largest state-owned enterprises. For example, State Grid is a big builder, as well as China Hydro and other companies, for example, in Latin America. And so, since many of these Chinese companies involved in the construction are SOEs, how does their status as an SOE bring any cause of concern if the cases against them are brought before the Chinese courts?
Okay. I was looking at so one example I can think of involved a project that SEPCO, it's the Shandong Electric, did in India. And things that I think constructing a coal-fired power plant, things went wrong. The Indian party called the guarantee, and SEPCO, so Shandong Electric, went to court to, stop, I forget which bank it was, their bank from paying out on the guarantee. So the Shandong High Court agreed with SEPCO. Whether it was they thought the arguments were persuasive or considered the status of SEPCO in the Shandong economy. I don't know. I mean, not, but the case was reversed at the Supreme People's Court level. So I would think this, this is a scenario that happens where the local, a local court might agree with the local company. But it's hard to pull these things out, whether it's local protectionism or.
So you feel that since that local courts would be more apt to find on the side of the local company, whereas the Supreme Court would be more interested in China's international position?
Yeah, definitely, because it affects the standing of China's banks. If banks abroad can't depend on a guarantee from a Chinese bank, right? And then that's a more important value than whether SEPCO, will have to pay out, X million US dollars to an Indian company.
Okay, thank you so much.
You're
Our
welcome.
next question is from Professor Brand, and he asks you to please elaborate a bit more on the concept of guiding cases. Is it correct that the SPC, rather than making law by hearing a case on appeal, uses guiding cases to highlight cases from lower courts and give them greater impact?
Guiding cases. Okay, so guiding case, this is an institution that arose, it started from like 2010. So before kind of Chinese style case law was recognized. So those were recognized, those were designated as quasi-binding or, highly persuasive back then. A case that would be an appeal from a lower court or any other kind of ruling by the Supreme People's Court. Yeah, so the guiding cases could be from the lower courts, but the Supreme People's Court leadership has approved them. So under the Chinese system, a case decided by the Supreme People's Court is not as persuasive as this one that has been designated as a guiding case.
Thank you.
Yeah, I hope that's clear.
Ron, did you want to add to that?
Yeah, maybe I will. Susan, in one of the areas that I work in, as you noted, is the recognition of foreign judgments, and that has changed dramatically in China in recent years with the first recognition of a U.S. court judgment by an in a court in Wuhan. But that then became noted as a guiding case by the Supreme People's Court, as I understand it. And could you elaborate a little bit on that process? Because it's not the way we expect things to happen.
That's right.
In the United States, and it doesn't seem to be the way it happens in other civil law countries as well.
Right. That's right.
Could you elaborate a little bit more on that process, which does seem to be particularly important from the outside, but not well understood?
Yeah. Well, there's a process where lower courts submit cases that they think are appropriate to be guiding cases up to the Supreme People's Court. And there's a lady at Stanford. There's a Stanford Guiding Cases project. So there's a lot of information there on the whole procedure, and she's translated a lot of these guiding cases. But it's a bureaucratic process, and then the case is not, it's not the original judgment itself, but an edited version of the judgment itself.
So does this then, in a way, it's a little bit, as you indicated, the court engages kind of in quasi-legislation.
Well, it's one of the many ways that it makes law, but I mean, the term makes law is, there are articles by people from the Supreme Court saying we don't make law, but it's another way that they create legal rules.
Okay, but it doesn't.
They need, but in the China, I would say in the Chinese context, and probably, if you could, have a Chinese judge, he would say as well, these are needed because the legislation is just not detailed enough.
Yeah. But in the traditional kind of Western legal system model, and we have the two, the common law and the civil law systems. In a civil law system, we would look to the legislation. In the common law system, we would look to the judicial decisions and look to a case being brought up to the highest court and then decided. And that would be the precedent. So it doesn't fit neatly into either of the boxes we create in the Western legal mind.
That's right, exactly.
So, yeah.
Yeah. But so a Chinese judge would look, he or she would look, and increasingly it's she, would look to the law first, and then to the judicial interpretation next.
Okay.
And then if there's a guiding case, fine, but there's like 100-something guiding cases. So that means there are thousands of legal issues that have no related guiding case.
But when there is a guiding case, that makes that lower court decision really much more important in that way.
Yeah. But then, as I mentioned earlier, there are all these other soft precedents.
Yeah. Okay, thank you.
Yeah, you're welcome.
So, Professor Finder, we have another question from Pamela Bookman, where she asks you if you could please speak a little bit more about the Chinese understanding of what international commercial law is. What extraterritorial impact does the SPC expect its decisions to have, and to what extent is it a two-way street, i.e., does it incorporate foreign law in any way when interpreting these issues?
Can you repeat that, please?
Sure. Could you please speak a little bit more about the Chinese understanding of what international commercial law is? What extraterritorial impact does the SPC expect its decisions to have, and to what extent is it a two-way street? i.e., does it incorporate foreign law in any way when interpreting these issues?
Yeah, so if I can address part of this question, so some of their decisions definitely have an extraterritorial impact, and that is and that's noticeable in the last year or two in the IP area, where the SPC issued a anti-suit injunction last year against is that a German or, and there've been a number of these anti-suit or anti-suit cases. There's been quite a few that parallel, parallel, what do you call it? The parallel jurisdiction. So the Chinese, because under Chinese law, the Chinese courts can take a case even if it's being heard abroad, and in some instances, they'll ignore an explicit choice of jurisdiction. Yeah, I guess I want to set aside what is Chinese international commercial law, because what the SPC is doing is related to current, Chinese economic policy. Yeah. Is it a two-way street? I mean, they're bound by their own law, which has it values sovereignty, so there's this concept of judicial sovereignty. So it values those things, it needs to implement those or uphold those.
Thank you.
Yeah, you're welcome.
I think we have time for one more question. And again, coming from an anonymous attendee, this person asks if you could please talk a little bit about what is occurring now in China with regards to transnational M&A, especially since the pandemic. Do you think the Belton and Road Initiative can act as a motivation for Chinese companies to acquire more companies outside of China, or vice versa? More broadly, what is your Chinese M&A outlook in the coming time?
Yeah, I mean, that's less an issue of the courts, more kind of the regulatory system. Also, I guess there are two parts. The one is the Chinese companies going out. In the past year or two, the government has imposed some controls on transactions that Chinese companies are doing abroad, right? So trying to stop these kind of trophy deals of buying football clubs, and that occurred a lot in the past. So deals can happen, I think, if the government thinks there's a good business purpose, but they're complicated rules on, what transactions can go ahead, with registration and what needs approval, et cetera. And then the other side is, what's happening in host jurisdictions, right? Because some countries are starting to have concerns about acquisitions of their companies by Chinese state-owned companies.
And how do those concerns sort of play themselves out, so to speak?
On the Chinese side?
The foreign side.
The foreign side, yeah. I think Julianne can address this better than I, but I think, it's an issue with the EU these days, right? I think there are discussions about, about state subsidies.
Okay. Well, thank you very much. And again,
Yeah, you're welcome.
On behalf of the Asian Studies Center and the Center for International Legal Education, I want to thank you very much for joining us at such a late hour from your home in Asia. And we deeply appreciate your taking time to participate in our conference. Thank you so much.
Yeah, you're welcome.
This brings to conclusion the first keynote by Professor Finder. At this point, we're going to take a short break of 10 minutes and restart at 9:25 for the next portion of our conference, which will look at the conference context, China's Belton Road Initiative with Professor Matthew Johnson. And then our first panel, Commercial Law Dispute Resolution in U.S.-China Business Relationships, beginning immediately after that at 9:40. So we welcome you back in a short a moment so that you can get some more tea, more coffee, something to drink, and we'll get started soon. Thank you very much. Welcome back to our conference on deals and disputes. Again, my name is James Cook, and I'm the Associate Director of the Asian Studies Center here at the University of Pittsburgh. Again, I'm very pleased to welcome an old friend and colleague, Matthew Johnson, to talk today about the Belton Road Initiative. Dr. Johnson is currently the founder and principal of Alta Silva, LLC, where he provides China-focused advisory, due diligence, and risk mitigation services across a range of private and public sectors. As an academic, he taught the history, politics, and foreign relations of modern China at the University of Oxford and also at Grinnell College. And he was also Dean of Faculty of Arts and Social Sciences at Taylor's University in Malaysia. A previous Fulbright Scholar and a board member of the Malaysian American Commission on Educational Exchange, he is currently a member of the National Committee on U.S.-China Relations. Dr. Johnson, please. We welcome you to give us your 15-minute talk on the conference context, China's Belton Road Initiative.
Thanks very much, Jim. Delighted to be with everybody this morning on the East Coast. It's a real honor to be speaking to you as a non-legal professional. I'm going to try to keep my side of the presentation to areas that I know a bit more about, such as the background on China's Belton Road Initiative and some of the political events, recent political events in China that are reshaping the political legal field in ways that are driven by policy in Beijing. So it's going to be the sort of 35 or 40,000 foot view, but I hope that it is useful for all of you. I want to thank the University of Pittsburgh School of Law, and particularly its Center for International Legal Education, and then of course the Asian Studies Center. Jim has been tremendous in welcoming me to the Pitt community, and I've really benefited from this association. So I'm very grateful. I want to start by sharing my screen and going into just, oops, let's put it back. Some of the great material that I prepared for today. Okay, so terrific. Like Jim said, I mainly focus on analysis of China's political economy, and so policies emanating from Beijing and in some cases Washington, and their implications for business and particularly investment between the US and China and other parts of the world as well. So I'm going to talk a little bit about the law, so to speak, from that perspective. But first, I want to bring in the Belt and Road Initiative, because I think obviously when talking about China's commercial relations and foreign relations and international law, we need to connect those issues back to some of the big foreign policies that are shaping how China interacts with the rest of the world. So that's part of what I've been called on to provide today. And what that means, I think specifically, is China's Belt and Road Initiative. So I'm going to cover the Belt and Road here for just a few minutes. I want to also then talk a little bit about some of the policies that are driving what I would call the internationalization of China's political legal system. And then, because I think this is inevitable when talking about really any issue in China today, and this goes for the broad space of the law, including the courts, including prosecution, including other elements of that system, as well as the perennial concern with political loyalty and political awareness, including among legal professionals. So to cover BRI here, we don't have to go deep into the text. One area where I do find that I can have great discussions with lawyers and others interested in the law is when talking about foundational documents, which I like to read closely. Also, now in China, because of the importance of the leader of the Chinese Communist Party in China's political system, in a sense, foundational documents are being produced all the time. And so under Xi Jinping, when talking about foreign policy, Xi's signature foreign policy, at least a significant chunk of it, is summed up under the umbrella of what is called the Belt and Road Initiative. Now, the main point that I want to make here about the Belt and Road Initiative is that there are really two components. If you've heard of it before, you've probably heard quite a bit about the infrastructure side of it. China investing in expanding infrastructure outside of China so as to better connect China's economy with the rest of the world. And so that kind of goes under the economic side of the Belt and Road. But when the Belt and Road was launched, so to speak, in a talk that, or by a talk that Xi Jinping gave in Kazakhstan in 2013, there was another side of the sort of proto Belt and Road that seemed to be very important to his thinking as well, which was the security side, and in particular concerning China's state sovereignty, which Professor Finder mentioned as an important, kind of background issue just a moment ago, and also territorial integrity. So, in other words, China's integration with the world through the Belt and Road Initiative is not just about economic integration, but it is also integration that is intended to protect and even expand China's interests outside of China. And that, I think we can sort of see that in the germination of the Belt and Road Initiative itself. And then as Xi Jinping continued to elaborate this idea, as he did a month later at the Indonesian parliament, the emphasis became more on regional economic issues within Asia, and then broadly economic development and China's sort of role in driving that economic development for the world as a whole. This is very lengthy. Again, we don't need to get into all of these points in detail, but what I do want to note is then that was in 2013. By 2015, this plan for the Belt and Road becomes much more fleshed out at the bureaucratic level. And in terms of the discussion today and for days to follow, I think it's important to note that it's the National Development and Reform Commission of China's State Council and also the Ministry of Foreign Affairs, and then also the Ministry of Commerce, which obviously plays an important role in shaping China's commercial legal agenda. These were the key institutions that took up the Belton Road as a project and made it into something that was a bit more concrete and geoeconomic and institutionally supported. So the foreign relations and commercial dimensions of the Belton Road are very important from a bureaucratic perspective as well as from a conceptual perspective. In subsequent years, this is directly from China's state media. The sort of vision of the Belton Road that I think has really been emphasized has been, this sort of idea of creating new geographic linkages between China and the rest of the world, primarily through infrastructure. The point I want to make here briefly, though, brief note also that in addition to the Belt and Road Initiative being taken up by China's main state bureaucracies, it has also been written into the constitution of the Chinese Communist Party as part of Xi Jinping thought, one could argue, and so it's going to be likely a very important shaper of China's foreign policy to come. That was in 2017. But the point that I wanted to make was, in addition to the infrastructural dimension, which includes railroads, oil pipelines, gas pipelines, ports. This is a fantastic graphic done by Merix in Germany. It's been fairly widely circulated at this point, and so I thought I would include it here for your reference. No, I see. With apologies, what's happened is that I've dropped a slide. So what I want to emphasize then is that in the Belton Road itself, and I think actually we see this if we go back to the way in which it was expanded here by China's major bureaucracies. It is not just about infrastructure, but it is about coordination of policy. So that's right there in the point under the Eurasian Land Bridge. Policy coordination, facilities connectivity, unimpeded trade, financial coordination, and people-to-people bonds. So the point that I really want to make here about the Belton Road, if you take anything away from this presentation, please take away that it's about more than infrastructure. It's about sort of embedding China's systems, China's commercial and foreign affairs systems, other systems in the systems of the world and impacting, that was a question that came from the last session, impacting global governance thereby. And so it really does have a policy dimension, which is very important to think about. And I think that therefore becomes important to understand when getting into then what it is that China, that China's leaders anyway, are trying to do with respect to the law. What is their legal strategy? So most recently, here we have a quick summary from Xi Jinping speaking at the fairly recently created, 2018, I think, was the first meeting, Central Commission for Comprehensive Law-Based Governance, which is the kind of flywheel that connects a lot of the different pieces of China's political legal system. And while its role, I think, is still being mapped out by people who look at China closely, it basically plays a role in setting the legal agenda for the entire country, I would say, including the National People's Congress. So Xi has gotten very interested in the idea of foreign-related rule by law and the use of law to better support and protect China's overseas interests, which of course are growing through investment and emigration and other forces that connect China more with other countries, other jurisdictions. And so in this context, the law is important as a tool that is part of China's policy toolkit in protecting its interests. Now, unpacking what foreign-related rule by law means is a lengthy task, and one that I won't be able to cover here, although maybe we can talk about it a bit in the questions. But at least in this fairly authoritative interpretation from the party group of the China Law Society that was published in People's Daily, so the most widely read party organ in China, it means accelerating the construction of legal systems that are applicable outside of China's jurisdiction, maintaining an international order with the UN as core, which is a phrase that has become increasingly common in China's political discourse, which is to say not shaped as much by the United States and Western countries. And to drive this point home, the article also made the point that the models and methods of other countries will absolutely not be copied. And these are all ideas that have been around since before Xi, but I would say that under Xi Jinping's leadership, they are definitely coming to the fore, and in particular, they are coming to the fore within the party state's political legal system, and therefore they are being, sort of driven down through the professional ranks of those in the law and law fields. And so this gets to my last point, finally, which is that it's hard to say exactly what this means, although certainly within the state's internal security apparatus, there has been real upheaval as a result of the launch of a new educational rectification campaign within the political legal field, meant to increase loyalty of anyone from judges to police officers to the party center, to Xi Jinping personally as a leader. And as somebody who watches China fairly closely, there's been some very interesting discussion about China's role in the world coming out of the political legal field or sphere itself. This is where, and some of this has bubbled up into the New York Times and other venues, assessments that the West is declining, that there is more room for China's legal model to grow, more focus on the external environment, meaning outside of China, what it means for China's continued growth, and therefore how China needs to shape that environment in order to ensure a continued growth and the longevity of party rule. And then also perhaps more mundane issues like the training of more legal professionals, legal talents. And I would say that these same developments, which are somewhat political and even ideological in nature, are being replicated across other fields, like foreign relations, like commerce, where you see Chinese officials taking a much, one would say, more assertive line in defending and promoting China's interests. So this leaves us with a few questions, which then bridge us over to the discussion to come, which I think are all fair questions and worth posing. I don't necessarily have the answers here, but again, especially for those of you who are kind of interested in the education side of this, I would say that this is where a lot of analysis kind of stops, and where things get a little more open-ended is with questions like these. So these are the new areas to be addressed. One is, how much the concerns of the party center really matter in the context of specific cases and negotiations. Depending on the situation, which of the goals and concerns that I've mentioned are more dominant, which less so. Are we talking about political goals being more important, commercial or economic goals being more important, or sort of law or rulemaking goals being more important, establishing precedent, establishing extraterritorial kind of impact and reach. Or how much the outcomes vary depending on where China has and PRC entities have more leverage, where they have less. Where differences in region might be relevant. So Asia versus Western contexts EU. And then finally, with the Belton Road itself, to kind of bring things full circle, is the Belton Road, a kind of master plan where actors on the ground know what it is that they're doing at all moments, at all times, or is it sort of more fragmented and improvisational and a kind of umbrella, as some have argued, under which China's state-owned entities and other firms, sort of go about pursuing their more bottom line focused interests under the cover of supporting state policy and being good corporate citizens in that regard. So we've done a bit of a whirlwind tour here. I hope very much that it's useful for you, and look forward to your questions.
Thank you, Dr. Johnson, for setting the stage for the discussion that is to come. I'm going to invite the panelists to all turn on their videos now, and we will move forward with the first panel discussion. And we're going to move from that introduction to the policy level down to what happens on the ground, very specific look at dispute resolution in US-China commercial relationships. And we're going to, first I want to say that there's a bit of adjustment to our program here. I have switched positions. I will be the moderator, and Katerina Osanova will be a panelist. You will see why that is the case as we move forward here, because she knows of what she speaks. But I want to set the stage for this. But I also invite you to, in the audience, to use the Q&A function to put questions in, because we do want to have a time for question after the panel presentations. We're going to have about 12 minutes from each of the 4 panelists. But first, I want to set the stage for this. I'll introduce the panelists all at once, and in the order that they will speak. Jean Huang, and I'm not going to repeat everything that's in the program. I invite you to take a look at that for more detailed information, because we really want to get to the discussion here. So my introductions are going to be incredibly brief and not do justice to the background of the people, but please use the program to look further in that. Jean Huang is an associate professor at the University of Sydney Law School in Australia, where she teaches in areas including private international law, which is particularly important, and international commercial law, both and international litigation and arbitration, important to our discussion today. Wenliang Zhang is an assistant professor at Renmin University School of Law in Beijing, also teaches private and international law, studied at the Center of Private and International Law in China at Wuhan, and is going to bring us the Chinese perspective here on these issues. Katerina Osanova is a trial attorney and manages the Office of International Judicial Assistance within the Office of Foreign Litigation at the U.S. Department of Justice. And that office is the U.S. central authority for the Hague Service Convention, which is important to our discussion today. And I would note, a personal note, Katerina is one of my former students, but she has done very well despite of that. And our 4th speaker is Peter Truboff, bringing the practical side. Peter is senior counsel at the Washington, D.C. office of Covington and Burling LLP. Nearly a half-century of experience in international law. He's been president of the American Society of International Law, been on the curatorium at the Hague Academy, and brings a very special perspective to us. Now, let me set the stage for the 4 of our panelists to have a discussion here. We're going to really bring it down to ground level by looking at a single specific case. It is a case that allows us to explore dispute resolution, but it allows us at the same time to deal with the front end, contract drafting, and thinking about how parties prepare transactions in order to avoid problematic dispute resolution. But we're going to look at problematic dispute resolution in order, in part, to think about what parties can do. And this includes choices between arbitration and litigation and dispute resolution, and that comes out in this case. It includes looking at, in the United States, state law, national law, and treaty law. We're going to, this case kind of deals with all of those. The ultimate questions here, as I see them, are in an age of party autonomy, when we give respect to freedom of contract, what are the limits that still remain? How does private international law or private choice fit with sovereign interests? And that's important in the US-China dimension. What choices can parties make in a contract? How do they make those choices? And what limitations are there on those choices? And we're going to look at some very specific questions on that. So in doing that, we're going to use a specific case, Rockefeller Technology versus Sinotype. And so I'm going to introduce the case here and then turn to our panelists. Rockefeller Technology is an American investment partnership. Sinotype is a Chinese company in Changzhou. And they entered into a memorandum of understanding in 2008. And importantly, that MOU had three clauses on dispute resolution. The first one provided that any notice required would be given by Federal Express or similar courier. The second one provided that the parties consented to jurisdiction of the federal and state courts in California and consented to service of process in accordance with the notice provision. The third provision provided that disputes would be settled by arbitration before JAMS, the Judicial Arbitration and Mediation Service in Los Angeles. And a dispute did occur in 2012. In February, Rockefeller filed a demand for arbitration with JAMS. Sinotype did not appear. They did give notice through FedEx to Sinotype. And because Sinotype did not appear, the arbitrator awarded Rockefeller in a default arbitration award $414 million plus US dollars. Now, one of the interesting elements that we probably won't discuss is that the amount here, because it was default, was based upon uncontested expert testimony on the increase in value of tech stock during the period in question, and Apple stock was rising very quickly, and that's what the expert used as a comparison. So we have a rather large arbitral award. In 2014, Rockefeller served Sinotype in China by Federal Express, as provided for in the MOU, in an action in California for purposes of confirming the arbitration award. Again, Sinotype did not appear, and the court issued a default judgment for Rockefeller in the amount of the arbitration award plus interest at 10%. Now, it's important to understand that this provision on service by FedEx has to be viewed in the context of the Hague Service Convention. The panelists will deal with this. The Hague Service Convention, two provisions. Article 1 provides that the Service Convention applies when there is occasion to transmit a judicial or extrajudicial document for service abroad. And Article 10 specifically addresses questions of service by postal channels, which are allowed in the United States, but not in many countries, and provides that to the extent that the state of destination does not object, the convention does not interfere with freedom to serve by mail. Now, the case went on and went in the California Superior Court. There was then a motion to set aside. Sinotype, after defaulting on the award, the arbitration, and defaulting on the court action to confirm the arbitral award, came in later and said, look, we now are quite interested in this because there's a judgment for $414 million plus interest, and we'd like to set aside that judgment. They moved to set aside, claiming in part that Sinotype had not been validly served with the summons and petition. And if they had not been validly served, there could be no valid judgment. And their grounds for this position was that the Hague Service Convention applied and that service had to comply with the Hague Convention and did not. Therefore, the judgment had to be set aside. The California trial court, the Superior Court, accepted or denied that motion to set aside the confirmation judgment and said the judgment stands. So Sinotype then appeals to the California Court of Appeals. The California Court of Appeals accepts Sinotype's argument and reverses, holding that service had not been in compliance with the Hague Service Convention. The treaty governs and prevents a valid judgment from having occurred. It went then to the California Supreme Court, which reversed the Court of Appeal and agreed with the trial court, holding that service had been proper and did not violate the Hague Service Convention. Now, one more step occurred. There was a petition for certiorari to the US Supreme Court. An appeal is not automatic. The Supreme Court has to grant the petition for cert. And the Supreme Court denied that petition for cert. At this point, I would just make two disclosures here. One is that I wrote an amicus brief on behalf of a group of law professors for the California Supreme Court case, and that another of our panelists, Jean Huang, wrote an amicus brief in support of the petition for certiorari in the US Supreme Court. So we have engaged in the process here. So that, I hope, sets the stage for our discussion. But in order to set the stage one step further, I'm going to invite Peter Truboff to simply tell us what has happened subsequent to that denial of the petition for certiorari when it was denied last fall. Peter?
Thank you, Ron. Briefly, we are waiting for another opinion from the California Court of Appeal. When Sinotype took its appeal from the trial court, it raised not only the service issue, but a bunch of other issues concerning the enforcement of the arbitral award. None of those issues were addressed in the initial Court of Appeal decision. When the California Supreme Court remanded the case back to the California Court of Appeal, the Court of Appeal invited the parties to brief any remaining issues in the case. Sinotype chose to say nothing of substance in its brief, but simply to rely on the arguments it had made in its initial appeal. Rockefeller said, look, under California law, after 100 days, if you haven't challenged an arbitral award, it's final and immune from judicial review. And so you've got nothing more to do here. Just to be safe, Rockefeller Technology went on to address each of the issues that had been raised by Sinotype, most of which went to disagreeing with the arbitral award, saying the agreement wasn't enforceable and so on. And Rockefeller Technology explained why none of those issues deserved any further attention from the Court of Appeal. So we're waiting for the Court of Appeal to rule. I checked yesterday, they haven't done so yet. And that's where we stand. Meanwhile, of course, you have the whole enforcement that's going to have to occur of the arbitral award, and that's at the trial court level, for which the record is not public. Thank you.
Okay, thank you, Peter. That sets the stage. So now we're going to turn to the panelists, who are each going to discuss different aspects of the case and what it means for U.S.-China dispute resolution on the ground level with private parties. And we turn first to Professor Jean Huang.
Okay, thank you very much, Lon. Thank you very much, Peter. Let me share my screen. So, okay. So can everybody see my screen? Okay. Yes. Okay. Yeah. So I'm going to focus on two issues. So the first issue is the lex fori, lex contractuus versus the law of the place of performance. Essentially is which law should be applied to determine the legal nature of transmission of judicial documents in another country. And the second is private contracting versus state objection to Article 10, especially 10A of the HCCH Hague Service Convention. So Article 10A is about the postal channels, and there are disputes regarding the meaning of saint. Article 21 of Hague Service Convention, it allowed the member states to object, to oppose to the use of method of transmission regarding Article 10. And China made a declaration to oppose the service of documents in the territory of People's Republic by methods, by post. Okay, and China's declaration is not unique. There are many other countries make either declaration or notification or reservation. So in the second part of my presentation regarding issue 2, I'm going to discuss in terms of public international law and the difference, if any, regarding declaration, notification, or reservation. So issue 1. To what extent can the mandatory provision of the place of performance, here is China, because the transmission of judicial documents take place in China by FedEx. So whose law, Chinese law in Sinotype, is neither the next fori. The next fori is the law of California, nor the lex contractuus, which may be California law, affect the rights of the parties. So I'm going to first do a very brief survey of national laws. I look at English law and Australian law. So first, the leading textbook, the Daisy's Conflict of Law, the most recent version, it provides that the rules or supposed rules that a contract, whether lawful by its governing law or not, will not be enforced insofar as the performance of it was unlawful by the law of the country where it was to be performed. So here we focus on the parties' agreement regarding how to notify the other party, and party agree that by FedEx. So this particular agreement, the issue is it cannot be enforced if the performance of it, if the transmission of document, there are disputes regarding the nature of transmission. So California court consider it is not service, it is notice. But the very important is here the physical transmission took place in China. So China is the place of the performance. So if Chinese law consider it is unlawful to transmit the judicial document for the purpose of a foreign proceeding, a proceeding in California. So according to Daisy's Conflict of Law, this agreement should not be enforced. So this is from the leading case, the Rally's case, and most recent, the case follow the Rally case is the 2020 case. Australian law is very similar to the English law's position. And let's look at the US law. First, the restatement, first and the second of conflict of laws essentially are very similar. So if we look at the restatement second, section 202, paragraph 2 makes clear that when performance is illegal, in the place of performance, the contract will usually be denied enforcement. So if party agree to notify the other party in terms of foreign judicial proceeding by FedEx, But here the performance, the transmission physically took place in China. And Chinese law consider this is illegal. And the contract will usually be denied enforcement. And the effect of illegality upon the validity of the contract should be distinct from the existence of illegality as such. And the effect of illegality upon the validity of the contract is subject to the proper law of the contract. But the existence of illegality is subject to the law of the place of performance. I think there is generally the law is settled regarding the existence of illegality should be determined by the law of the place of performance. But the effect of the illegality should be subject to, in this case, is California law. The restatement, the second, further provide the following will first decide whether illegality does in fact exist by reference to the law of the place of performance. If illegality is found to exist, the following will look to the local contract laws of the state selected by application, here may be the proper law of the contract, to determine the effect of its illegality. And the second part of my argument, my issue 2, address on the effect of illegality upon the validity of the contract according to California law. But let's first finish the question to issue 1. So I imagine that some panelists may not agree with me, and the disagreement may come from 3 aspects. So the first one is which law of the place of performance is violated. The issue of Chinese law is what's the penalty for FedEx or for plaintiff or defendant, especially for plaintiff. They serve the Chinese defendant by FedEx. There is no penalty, I have to say. And I understand Professor Wen Liang will talk about the judgment recognition and enforcement. This is an issue, but this is not a penalty. There is no criminal charges. There is no administrative charges. So this is the issue for the foreign court to consider the illegality issue. However, I think it's very clear that based on China's declaration under the Hague Service Convention against Article 10, and also based on Chinese civil procedure law, the transmission of a document, foreign judicial document, for the purpose of foreign proceeding violate overriding mandatory law in China. And it is the public policy, very clear public policy of China. So I think these 2 points are not disputed. So even there is no criminal charges and the illegality of transmission of the relevant judicial document is, in my point of view, in my humble view, is no question. And the second disagreement can be made regarding procedure versus substantive. So procedure issues should be subject to lex fori. So the argument is the service of process is a procedure issue. So California law should be applied. However, very important is we need to understand the underlying policy, why the procedure issues should be subject to lex fori. This is because the judges are most familiar with its own law to regulate the modes and conducts of the court proceeding. However, in Sinotype, here the transmission of documents physically take place in China. It is not in the California court, in its territory. It is in another country. So I will argue that the traditional private international law regarding lex fori should be applied to procedure, does not apply in this case. And the third disagreement that may be raised on the policies of the state with the dominant interest in the issue to be determined. So which state has dominant interest? Is China or California, United States? And also regarding party autonomy. So the comment in restatement second explicitly indicate less weight to the justified expectation of the parties. So party autonomy should weight less compare with the dominant interest of a state in the issues to be determined. Here I argue that because the declaration under the Hague Convention demonstrated China's overriding mandatory law and public policy. So China is the state with the dominant interest. And so this is my tentative conclusion for issue 1. Okay, so when judicial documents are physically transmitted in the soil of a member state, allowing another member state to unilaterally determine the concept of service in order to exclude the application of the Hague Convention will inappropriately expand the non-mandatory character of the convention. Okay. The issue 2 addressed the public international issue regarding party autonomy versus state sovereign interest. So the question is whether a private party can opt out of a state's objection to Article 10A through a contractual agreement. First, very important, the private parties are not party to the Hague Convention, so they cannot opt out of it. So here the issue is party can choose another state's law. So for example, party choose a member state X the law. And the issue will narrow down to be whether a member state X, here California, should comply with a member state Y, China's objection under Article 10A of the Hague Service Convention. My argument is it is not only a matter of state X domestic law, what does California law say, but also whether it has an international obligation under the Hague Service Convention. So the first is a terminology issue regarding reservation versus declaration. Some member states use reservation, some member states use declaration under the Hague Convention regarding Article 10. So here I refer to Vietnam Convention on the law of the treaties and the ILC guides to practice on reservation to the states. So both definitions are very consistent. It emphasizes reservation means a unilateral statement. However phrase or length, it can be a notification, it can be a declaration, it can be whatever. But its legal nature is it purports to exclude or to modify the legal effect of a certain provisions of the treaty in their application to that state or to that international organization. The reservation and declaration should be distinguished from interpretative declaration. So the interpretative declaration does not intend to exclude or modify the legal effect of certain provision. This is their key difference. So I refer to the ILC guidelines, especially Article 1.3. So if we go back to the Hague Convention, it is obviously China's declaration under Article 21 against Article 10 of the Hague Convention. The purpose is to exclude the application of Article 10 to China. So it is a reservation under VCLT, and it is not an interpretative declaration. Okay. The second part of my argument is acceptance.
I'm going to have to ask you to wrap up here very quickly.
Right. So the United States, because it keeps silence, so actually US accept the China's reservation regarding Article 10. And what's the legal effect of the reservation? And very important is the Article 21B of the VCLT. It modifies those provisions, Article 10, to the same extent for that other party in its relations with the reserving state. So my conclusion is China's declaration regarding the postal service under the Hague Convention should be considered as a reservation. And China's reservation is accepted by US either because the Hague Convention does not require any subsequent acceptance or because of US tacit acceptance of reservation. And according to Article 21B, of the VCLT, China's declaration modifies Article 10 to the HCC Convention in U.S. relation with China. So the U.S. has an obligation, an international obligation to respect China's reservation under the Hague Convention, which is a part of the U.S. law. Therefore, the transmission of the documents in the Sinotype case, it is illegal under Chinese law, and it should be considered as illegal under US law as well. So this is my humble view. I'm open to any questions. Thank you.
Ron, you're muted. I'm sorry.
Thank you, Professor Huang. So we turn now to Professor Wenling Zhang. Professor, it's all yours.
Hi, Ron. Hi, friends and colleagues. My name is Wenling Zhang. I'm from Renmin University of China, School of Law. I feel very honored to be here to meet all you here and share some preliminary observations about the topic of China-US judgment recognition, especially with a focus on the Rockefeller case. So this is a case that is very attractive, and Peter and Ron have just introduced. The case actually involves both arbitration procedure and also litigation process. I would like to discuss this case from the perspective of the possible recognition and enforcement of the Rockefeller decision in China, if any, the Rockefeller decision was brought before Chinese courts for recognition and enforcement. So first of all, I think that let's briefly review the legal frameworks for recognition and enforcement of foreign judgments in China. And I would like to focus on the China-US judgments recognition. Right now, China has concluded a number of bilateral treaties. As of today, there are 39 bilateral treaties on judicial assistance, which mostly have a provision on judicial assistance. For example, the first Sino foreign bilateral treaty dated back to 1987. That is a bilateral agreement reached between China and France. The latest bilateral agreement was reached between China and Iran in 2016. But unfortunately, between United States and China, we have not thus far reached this stage. For multilateral convention, that may provide another channel for possible recognition of foreign judgments in China. But between United States and China, unfortunately, there are no applicable international treaties. For example, the 2005 Choice of Court Convention, China signed it. United States also signed it, but both sides have not opted for ratification. So the 2005 Choice Court Convention cannot be of any help here. And also we may refer to the 2019 Hague Judgments Convention. I think Ron is very familiar with this convention. Unfortunately, this new convention was neither signed by China or the United States. But anyway, from the perspective of multilateral conventions, I must refer to a convention that is the 1965 Hague Service Convention. Professor Jin Huang has referred to this convention for several times in discussing the service of documents abroad. But this convention is of a very limited use in terms of discussing the recognition and enforcement of foreign judgments. So in this context, I think for talking about recognition of the US judgments in China, especially the Rockefeller decisions, we must refer to Article 282 of China's Civil Procedure Law. China's Civil Procedure Law, Article 202, is very brief. It actually introduces only 3 requirements. First, the foreign judgment must be legally effective. It means that foreign judgment must be final and conclusive. The second requirement is that there must be international treaties or there exists the reciprocal relationship. And the third requirement is that recognition of foreign judgment must not run afoul of Chinese public policy. You see, these are very three general requirements. So now let's examine whether the Rockefeller decision would fit into these requirements if any subsequent recognition was brought before Chinese courts. I think for the first requirement, namely the finality requirement, it is not a concern in our case here. Actually, the Chinese practice also reveals that it is rarely invoked. As regards the public defense, it is a likely factor, but I don't think it will pose a great barrier. Chinese practice also demonstrates that this is also a rarely cited defense. I would like to dwell on the second requirement, namely the reciprocity requirement. This requirement has long been cited by the Chinese courts in blocking foreign judgments. And it actually, based on my research in the 2013 article, it is the most cited defense for Chinese courts to refuse recognition and enforcement of foreign judgment. So let's try to understand what a reciprocity requirement means in the context of Chinese recognition rules. Chinese law would like to, in fact, it is the interpretation given by the Supreme People's Court of China. China's Supreme Court defines the reciprocity and de facto reciprocity. What it means is that if any foreign judgment are believed to surpass the reciprocity threshold, there must be prior recognition of Chinese judgments by the corresponding foreign countries. So it means that foreign countries must take the initiative to recognize Chinese judgments. Only after that can Chinese court deem the existence or establishment of a reciprocal relationship between China and the corresponding foreign country. Luckily, today we have seen the full initiative recognition of Chinese judgments by foreign countries. For example, we can see the countries from both civil law countries and also common law countries. Here is a list. For example, Australia, Canada, Singapore, New Zealand, and the United Kingdom from a common law jurisdiction have taken the initiative to recognize Chinese judgment. Germany, Israel, the Netherlands, and South Korea all have taken the initiative to recognize Chinese judgment. Basically, according to the traditionally held conception of de facto reciprocity, this prior recognition of Chinese judgments would be deemed as satisfying the reciprocity threshold. And also, it is noteworthy that US courts have also recognized Chinese judgments on an initiative basis. We all may remember the 2009 Hubei-Gazuba versus Robinson Helicopter case. In this case, the California court recognized a Hubei judgment. So this is a landmark case. And actually, based on what we have just discussed about China's understanding of reciprocity, it should be presumed that a reciprocal relationship is established between the United States and China. Yes, and actually some Chinese courts followed suit. For example, I think Professor Ron has also mentioned this case about the 2019 Liu Li versus Toli case. The Wuhan Intermediate People's Court recognized for the first time American judgment from California. And also in 2018, a Shanghai Intermediate People's Court also recognized a United States court. So let's refer back to the Rockefeller case. I would like to, or we may ask whether reciprocity is satisfied or would be satisfied if Rockefeller decisions were brought before Chinese courts for recognition. This is a very key issue. I would say that it is very likely, since the situation is becoming more and more positive. And also, here's a list of interaction between China and the United States in terms of mutual recognition enforcement. You can say there are several cases already on which United States courts have recognized Chinese judgments, and also Chinese courts have recognized United States judgment. So this picture is really promising. And then can we be sure that there's definitely a reciprocal relationship between China and the United States? Yes, nowadays we can see a follow-suit recognition between China and the United States, but I still doubt that there's a firm reciprocal relationship established for recognition of United States judgments, including the Rockefeller case. Why? Practice shows that there's a more likely situation. It is more likely than not for the United States judgment to be recognized in China, mostly due to the so-called establishment of a reciprocal relationship between China and the United States due to a number of United States recognition of Chinese judgments. And we can say also that Wuhan Court and Shanghai Court followed suit to recognize the United States judgment. But there's also a court, at least one court, that is Nanchang Court refused to recognize United States judgment for lack of reciprocity. Although the judgment data in that case clearly stated that in 2009, the United States court had already recognized a Chinese judgment. So there's another different picture about whether reciprocal relationship has already been established between China and the United States. Yes, there are at least two basic theories. The first one is that there is a reciprocal relationship established between China and the United States as a whole. We know that the United States is comprised of 50 states and Washington, D.C. They have different legal systems, so there are different jurisdictions for recognition and enforcement purpose. So others may just doubt whether a real reciprocal relationship is established across the United States between China and all the United States as a whole. So that's the key point here. And I co-authored with Professor William Dodge, and we wrote an article about this point. We argued that because in the United States, although there are 51 jurisdictions, but most states, actually 36 states, have already adopted the Uniform Act on recognition of foreign money judgments, that's which include the 1962 Uniform Act and the 2005 Uniform Act. So if a Uniform Acts are adopted, so that means the recognition rules across these states are more or less the same. So that means that Chinese judgments have more or less the same chance to be recognized in these states which have adopted the Uniform Act. We also find that in the 14 states of the United States which practice common law, they actually also adopt substantially similar rules to the states that have adopted one of the Uniform Acts. So from this point of view, we suggest that United States may be taken as a whole for the purposes of satisfying the reciprocity requirement in China. And we would like to see the continuing and positive follow-suit interaction of recognition between the United States and China. In this sense, if this mindset were followed, I believe the Rockefeller decision may surpass the reciprocity requirement if any recognition was sought before Chinese court. Lastly, I would like to give passing comments on the service requirement. Professor Zhang Huang has already touched on this issue, but I would like to discuss it from the perspective of recognition and enforcement of foreign judgment in China. Yes, from China's civil procedure law, I have just referred to it, namely Article 282 of China's civil procedure law. There is no service requirement, but as you all know, there is 1965 Hague Service Convention, and China has made a declaration or reservation whatsoever. And this convention was signed and ratified by both United States and China. And most important of all, in past Chinese practice, Chinese courts have repeatedly resorted to this defense for blocking foreign judgment. For example, I just cite 3 cases here. The first case is a 2001 case. It is about Beijing No. 2 Intermediate People's Court refused to recognize Belarusian judgment for the sole ground that there was services by mail. Okay, and the second case can be traced back to 2005. It was the Wenzhou Intermediate People's Court that blocked recognition of a French judgment. We can recall that actually in 1987, China and France signed a bilateral judicial assistance treaty. But in this case, basically the Wenzhou Intermediate People's Court blocked the recognition of the French judgment on the service requirement, namely by mail. And another case is about 2009. This case is about the Beijing No. 2 Intermediate People's Court refused to recognize a separate judgment, also solely on the ground of service by mail. You can also find that between China and Cyprus, there is a bilateral treaty on judicial assistance. And in this case, the separate judgment was denied recognition on the service requirement. So I would like to just give the basic pictures and especially the general issues about recognition of foreign judgments in China with a focus on the Rockefeller case. And in the Rockefeller case, I think the most formidable hurdle would be the service requirement. I don't think the reciprocity would pose much barrier if any recognition would be brought before Chinese courts in some big cities, for example, Wuhan and Shanghai. But the service requirement will be really a serious problem. I think so. Okay, so I think I would like to stop here, and I would like your comments or questions. Thank you, Ron.
Thank you, Wen-Yang. So now we're going to move back across the ocean and go to Katerina Asanova, who does work for the Department of Justice, but is not speaking on behalf of the Department of Justice today. Katerina?
Thank you, Ron. And thank you to the Asian Studies Center and Sealy for the invitation to participate. As Ron noted, I am here in my personal capacity, and any opinions and views I express are not those of the Department of Justice, but are my own. That said, I do bring some experience with me that I can share with you in my role as a senior trial counsel at the Office of Foreign Litigation in the Department of Justice. I oversee and manage the Office of International Judicial Assistance. I'll refer to it as OIJA. That is the name that we have given ourselves in our function as the U.S. Central Authority for not only the Hague Service Convention, but also other conventions you are likely familiar with, including the Hague Evidence Convention, the Inter-American Convention on Letters Rogatory, and we also receive and work on requests for judicial assistance in civil and commercial matters received through diplomatic channels, typically from non-convention countries. Just a little bit to give you some context about the U.S. Central Authority. We have delegated basically the ministerial function of service to a private process server. We get over 9,000 requests for service, at least we did pre-pandemic. So you can imagine that we need a company to handle those requests for service. Directed at private individuals and companies from over 80 countries. And like I said, we do have a private process server company that handles all of those requests for service. We have taken some steps in the last few years to evolve with the times. We've embraced electronic transmission of requests for service, so they can all be sent electronically to the designated company and uploaded. They are then still printed and personally served. So one important note is that we do only effect service by personal service if submitted through the Hague Service Convention. My office is still the central authority for all other purposes, and we also accept requests for service on the United States, its departments and agencies, and then again, issue the appropriate certificates. Another important function of that we do not do is outgoing requests for service. So unlike, for example, the Chinese Central Authority, which handles incoming and outgoing requests for service, like many other central authorities, the way we are set up is that we are not required to process outgoing requests for service. Competent authorities, according to Rule 4, are competent to transmit requests for service directly to central authorities and arrange for service in foreign countries. That being said, we obviously have a vested interest in the interpretation and implementation of all of these conventions, including the Hague Service Convention. We maintain close cooperation with central authorities. We're involved with the Hague Conference. And again, we do provide guidance, general publicly available guidance to private parties, counsel in the United States, foreign parties, and certainly US government attorneys. So while our role is somewhat limited, we do very much try and promote uniform, consistent application of these very, very important conventions in private international law. One aspect of this case that some of you may have noticed is that my office received a letter from the Chinese Ministry of Justice. In this case, in the Sinotape case, it was actually filed as a supplemental brief in the petition for cert, so it is publicly available. So that's an example of where, we do hear from foreign states when they believe that either a court or an entity, an attorney, a private litigant is acting in contravention of their laws. So China's not alone in that. We hear from countries often. It's either us or the State Department, whether it's a letter or an email or a phone call or a diplomatic note. We do hear from countries who have expressed their views. China in particular is very active in filing their own amicus briefs and statements of interests in various litigation, expressing their views on behalf of the government. So we're starting to see that more and more as well, that again, foreign states are weighing in on US litigation matters. So I thought I would just share a few, again, my personal views about this case, and then provide some more context. For us, for my office, we very much emphasize the mandatory and exclusive nature of the Hague Service Convention. If the very important aspect is met, which is that documents need to be transmitted abroad, and that a private party cannot waive Hague Service Convention provisions. So something that you'll hear about the distinguished speaker right after me is, the continued need for lawyers, which is if you want to, I don't want to say avoid, but if you want to contract around the application of the Hague Service Convention, the importance of contract negotiation and contract drafting in order to make sure that you avoid the transmission of documents abroad, and therefore you, contract for a method of service in which service is affected in the forum state. So perhaps in this particular case, if service on Sinotype could have been affected on an agent for service in the United States as opposed to China. So again, we very much emphasize, and I emphasize the objection that each contracting state is able to make under Article 10. These objections are, a country's sovereign right to make. They're not an individual's ability to waive away any objections or contract around objections if judicial documents need to be transmitted abroad for service. And again, so these objections are held by countries, not by individuals, and therefore cannot be waived or disregarded by even by contract. So the best way to think about having to affect service, I think, in my opinion, would be to again, affect service in the forum state. There is talk about waiver, and again, the California Supreme Court in this case talked about whether formal service had been waived. I'm definitely not convinced that service had been waived in this case, looking at the language of the MOU. But even waiver itself, I think, is rather complicated. And again, so that I think contracting for affecting service in the United States would have been the first option. I think waivers can be a little trickier. One, they are waiver requirements. So a waiver in itself has waiver requirements, and you cannot waive the waiver requirements. So that's something to look at. And another thing that I think is rather interesting about waivers is the possible implications they could have. For example, we are under the impression, and we've received advice that even a request for waiver that is sent to a foreign party could be in contravention in foreign law. And specifically, the country that we had looked at was the Swiss blocking statute in Switzerland. And whether a request to waive service that was transmitted and sent to a Swiss entity could in fact be in violation of the Swiss blocking statute. The reason being is that a request for waiver generates legal effects if in the absence of a reply or a refusal to waive that may in fact lead to a default judgment. So because a request for waiver itself could produce a legal effect, it may not be permitted by foreign law. So again, even waivers, I would say, I would caution, would need to be thoroughly looked at in the contract negotiation and drafting process. Something that I think we should note is that, in our legislation and certainly in the Supreme Court jurisprudence on these conventions, especially the Hague Service Convention, there's quite a bit of deference and recognition of sovereignty, of foreign sovereignty. If you look at the Federal Rules of Civil Procedure 4F, which governs the service of process abroad, there's quite a bit of recognition on foreign law 4F1 certainly is on internationally agreed means of service, including the Hague Service Convention and the Inter-American Convention. Like I said, deference does need to be made to any objections, reservations, and declarations foreign contracting states have made pursuant to those conventions. The second part of 4F talks about, methods of service as prescribed by the foreign country's law for service, or it talks about as the foreign authority directs, and then the or unless prohibited by the foreign country's law, and certainly even the alternative methods of service under 4F3, the beginning language starts with by other means not prohibited by international agreement. So I think that clearly demonstrates an intent to recognize and defer to foreign law, especially in regards to service, which in so many countries, in most countries, is a sovereign judicial function. Which brings me to the most recent Supreme Court case on the Hague Service Convention, Water Splash v. Menon in 2017, in which the Supreme Court finally resolved a 25-year circuit court split and district court split over the meaning of the word send in Article 10A of the Hague Service Convention, and whether Article 10A could be used to serve documents abroad. This was a case that the United States government also filed an amicus brief on as well. We were very interested in the correct, and what we believed was the correct interpretation of Article 10A. And the Supreme Court concluded in that case that Article 10A does not affirmatively authorize service by postal channels, but it is permissible, and it established a two-part test only if the receiving state had not objected to service by postal channels, meaning there had this receiving state had not lodged an Article 10A objection, and that service by postal channels is authorized by otherwise applicable law or the law of the forum. The Sinotype case and the Water Splash case are a little bit different in that the Water Splash case clearly governed or was about formal service of process that was transmitted abroad to Canadian defendant. Here, the California Supreme Court did not view this as formal service. It had basically, it said that parties had waived former service, and this was a way to notify the parties. Again, I'm not sure I agree with that reasoning in that documents were still transmitted abroad. The Sinotype's address was in China, where the documents were transmitted. It had to do with a judicial proceeding and not an arbitral proceeding, in that the Hague Service Convention does not apply to arbitration proceedings. This was in regards to recognition of an arbitral award in a California court. So I would probably say that this was very much, service in connection to a judicial proceeding in a civil or commercial matter and squarely within the realm of the Hague Service Convention. But I think what's important to know from the Water Splash case, in my opinion, is again that the Supreme Court did establish a two-part test, and the very first part of that test is, what is the view of the foreign state, of the contracting state on postal channels, and due deference is given to a country's objection to Article 10A. So once again, I think both looking at the federal rules of civil procedure, looking at the most recent Supreme Court case, there is, kind of uniform recognition of the importance of service of process of a foreign state's, contracting state's objections and reservations and declarations it has lodged pursuant to the Hague Service Convention. So I think I very much, I guess I'm saying is I agree with what has been said so far by Professor Huang and Professor Zhang about the fact that there has to be a recognition of China's laws and China's objection to Article 10, and that certainly perhaps would have resulted in a different outcome, should have resulted in a different outcome in this case. But one of the things I wanted to, I guess, end on are kind of the practical aspects of all this, because we can talk about this in a kind of a vacuum, but we have to talk about it in the context of these are litigants who are interested in moving their cases along, and U.S. judges who are focused on efficiency. One of the aspects that has been problematic for the operation of the Hague Service Convention is the delays that countries sometimes experience with effecting service pursuant to the convention. The U.S. is not in any better position to critique any other country, as we are definitely also, at any given time, facing a number of delays with executing, like I said, over 9,000 requests for service that we get per year. But that being said, I think it is important to understand that a lot of these kind of contracted terms of service or alternative forms of service that, again, may not comply with Chinese law, usually as a result of when service through the central authority is seen as futile or it results in excessive delays. So I think one aspect that every central authority or every contracting state needs to work toward is greater transparency and certainly greater efficiency with the execution and completion of these requests for service. I think that will, in time, encourage greater use and greater compliance with the terms of the Hague Service Convention and with the various objections and reservations lodged by contracting states, if service through the convention is seen as effective and efficient. Like I said, I think that is one of the causes, besides bad contract drafting, I guess, but is also one of the reasons I see quite a bit of case law that I perhaps wouldn't agree with, like again, on its face would not comply with, for example, China's objections. But a lot of that is due to, again, perception even of delays of execution of requests for service. So I'll gladly entertain any questions. I definitely think it's important to have this conversation. Certainly my office is interested in ensuring and urging compliance with foreign law and our treaty obligations. We certainly provide guidance to that effect to any parties and anyone that we receive questions from. We understand the reciprocal effects of cases like this, not just for judgment enforcement, but generally on a much larger scale. And I'm very grateful to have a platform here to be able to engage with the other speakers.
Thank you, Katerina. We now hear from the practitioner, Peter.
Thank you, Ron. I'm going to share my screen. Okay, and now we'll go to the all right. I'm having trouble, Ron, getting it to there it is. There we go. Thank you, Ron, and I appreciate that the hour is late, and so I'm going to try to limit the amount that I say so we have a little time for questions here. The issues raised by Rockefeller Technology and that our prior speakers have raised aren't going to be solved today. And for a practitioner, the question becomes, of course, well, what do I do in writing a provision in a contract dealing with dispute settlement? And how do I go about writing a provision that's going to be effective? Gene has warned us, Gene Wong, Professor Wong, has warned us that to some extent it depends on where you sit. If you're a Chinese party, you want to be sure you don't do something that waives the Chinese reservation. And if you're a US party, you want to think about what's going to happen if you need to enforce your judgment in China. I'm thinking about the case of a party to an agreement where there are assets in countries and you want a provision that enhances the chances of effective enforcement of any ruling on a dispute settlement, and how you should word that provision. And what I've come up with is what I think are a checklist that a practitioner needs of the actual language that one would want to use. And I see the need to have 7 different features in an agreement dealing with dispute settlement if you're going to not only address the problem we've been discussing particularly, but more generally ensure that you have a provision that's going to hold up. And I'll go through each of those fairly quickly, making clear that these are optimal. You're not going to get them in every agreement. You need to think about how is it going to, which ones are most important to the particular transaction I'm involved in. You also need to consider the relationship between the provisions you're putting in your agreement and the content of the domestic law which you're going to designate. And as I'll show in a moment, also the provisions of an administrating agency for arbitration. So I have identified 7 different fact provisions that I would include in an agreement. The first is governing law, which is pretty straightforward, except one wants to be sure to exclude choice of law, so you don't have a renvoi. You deal with the substantive law of the country that you've chosen for your governing law. Second, I include a provision on submission to jurisdiction, naming a particular court, and having selected it, then each party should say, I will not object to personal jurisdiction. And I'll say in a moment, I won't object to the service provisions we've agreed on or the notification provisions we've agreed on. I won't object to venue. I won't raise forum non-convenience, and I will agree to enforcement of the provisions that we're agreeing to. And in addition, I would put a provision in on what happens if you don't comply with the agreement, namely, if you challenge it, you end up paying costs. The third provision I would put in it in an agreement deals with the Hague Convention question we've been talking about. All of the cases emphasize the purpose of service, which we need to focus on. What's the purpose of service? It's to provide actual notice of proceedings. And if parties want to agree that notice of proceedings should be given in a particular way, I don't believe the Hague Convention precludes their doing so, nor necessarily does the law preclude their doing so, so long as they think about where they want to enforce their judgment. And so I have come up with what I think are 2 different provisions, one of which has been mentioned, the other of which I will note here, namely, first, the naming of an agent for service of process, so that you don't have to have any transmission of documents outside the jurisdiction. And second, a notification provision for notice through courier service. Again, what's the purpose here? The purpose is to ensure actual notice. So the first is the appointment of an agent for service of process. I think there's general agreement that's allowed. The convention doesn't preclude that or even have people arguing about it. You want to make sure you do it in accordance with local law. You're not waiving. You don't necessarily have to have a waiver of the convention, but as you'll see, I suggest we have one just to avoid any challenge under Schlunk. The second way I would propose providing notice is through a courier, in which you specifically name the courier service and provide for confirmation through email and so on. My point being, this could be supplemental to the naming of an agent for service. I also believe the Hague Convention does not preclude having it as the sole means for notification where parties wish to do so. Incidentally, on water splash, Fortunately, Water Splash involved Canada, which hadn't objected under Article 10. So when the court went back to the case, there was no problem with the service that had been affected. What do we do about reciprocity? And our Professor Zhang has focused on this. I would put in a provision that explicitly accepts that there is reciprocity. Yes, there is precedent here. Yes, if you litigate it, you should win. But my point is, parties can say, look, we know that there is reciprocity. We come from a country that accepts there's reciprocity with the United States. So if I'm a US party contracting with the Chinese party, I would expressly state that. What will the Chinese courts do with that? I don't know, but it's certainly better than just waiting to see whether the issue arises during litigation. And I would say, in addition to recognizing that there is reciprocity, having a promise not to raise it as a defense. Now, what about arbitration? I think you need to think about two things. One is adjustment and the other is enforcement. The adjustment issue comes up in a case that I've cited here that Ron Brand has brought to our attention out of North Carolina, because they're the rules of the particular institution, the American Arbitration Association, said something about service, and you needed to adjust your own contractual provision to take account of what the rules said. Are you supplementing the rules? Are you overriding the rules? You need to look at the rules and adjust your contract provision to take account of what the rules say. The second is enforcement. If you've got an arbitral award, you obviously need to deal with the question of enforcement. Again, the rules may say something about it, but if they don't, you certainly want to think about a provision that provides for enforcement of the arbitral award, and you can even have it broader. It could also deal with enforcing the agreement to arbitrate. You could have it deal with enforcement of rulings of the arbitral tribunal. My point being, your clause, if it's going to cover all bases, should take account of what you would do. As to the arbitration provision itself, there are plenty of good models for that. You don't need to, I haven't tried to address that here. I would recommend Gary Bourne's new edition of his book, which has some excellent models. So what is the bottom line here about enforcing a judgment that results from using the clause I'm proposing? And I think Professor Wong has it right. It all depends on where you sit and where you want to take your enforcement. It's certainly likely to be effective and allow enforcement in states that have not taken an Article 10 objection. The use of the designated agent isn't contested in most countries, and many countries did not file Article 10 oppositions, including not only the United States, but the United Kingdom and France. And as I just mentioned a moment ago, Water Splash shows us that the Canadians have not either. Different story, and I think a different question, again, focusing on Professor Wong's point, it depends on where you sit, where you want to think about enforcement in states that are Article 10 objectors. And each of them has used rather similar language. There's some very important countries there. And you need to recognize, appreciate that your judgment may not be enforceable. If you have had an agreement of the kind I'm proposing, your judgment may not be enforceable in those countries. I'm not entirely sure all of them would take the view that our colleagues from China have said that their courts would take, but certainly you have to anticipate that could be a problem. There are other issues here. Are there other provisions in the proposed agreement that I've mentioned that the courts of China or other nations wouldn't enforce or honor? Are there improvements or additions here? And are there other issues to consider when there's an agreement to arbitrate? That's a quick run through on something that I could have taken more time on, Ron, but I know you want to have some time for questions. Thank you very much.
Thank you, Peter, and thank you very much for being concise in all of that. Very much appreciated. And if you can stop the screen sharing there, then we'll all come back. we do have an excellent question from Aaron Simowitz, but Aaron, I'm gonna put you off for just a minute and exercise the moderator's prerogative. First, I want to thank all four panelists for wonderful presentations, and I want to try to put the thing back into broader context. 4 points. One is legal system differences, and one of the things we see here, and it's clear in the Hague Service Convention, but is very important, and it's important for litigators, contract drafters as a policy issue, the very different way in which legal systems approach the same problem. Service of process in the United States is not a sovereign function. Anybody above a certain age who's not a party may serve process and sign a document that says they've done so, pretty much. In the rest of the world, it's a sovereign function, and service of process, not in accordance with local rules, is not just a private matter. It's not just a matter of whether or not you have real notice. It's a matter of whether you violated sovereignty. Second, the BRI context, the Belton Road initiative here. I think when we get into this dispute resolution area, we see China very much involved in the global picture. They are a party to the Hague Service Convention. They are a party to the New York Arbitration Convention. They have signed both the 2005 Choice of Court Convention in The Hague and have been very active with the Judgments Convention, been very active with the mediation, the Singapore Convention, very much involved in this, trying to become a player in all of this. But it's important, as we saw in Matt Johnson's presentation, that they use a term that we don't use, rule by law instead of rule of law. And I would suggest there's an important distinction there in that Belton Road context. Third point, this case began in arbitration, and we've been discussing litigation and service in the litigation. We didn't discuss service in the arbitration because the Hague Service Convention doesn't apply to service in arbitration. And I still think that Rockefeller can take the arbitration award to China, and then we're talking about the New York Arbitration Convention, not the Hague Service Convention, and service doesn't come in to the question, to the matter at that point. And there is an obligation to recognize and enforce that arbitral award. Final point, number 4 here is, and this is where I get to the question that Aaron Simowitz has posed. Professor Simowitz has suggested that we all agree the California court got it wrong. I'm not so sure they got it wrong.
Oh.
Because here's what the California court said, and it's consistent with Schlank, the earlier opinion of the US Supreme Court, and that is that the question of whether or not you have occasion to transmit documents for service abroad is determined by local state law. In Schlank, it was Illinois law. In this case, it was California law. And if you read the California Supreme Court opinion carefully, they're going to state law for interpretation of the contract, and contract interpretation is state law. What did that contract mean? Now, did that contract clearly say that service doesn't require occasion to transmit documents for service abroad? I don't think so, but I think they said it does. And the final arbiter of what California contract interpretation law is the California Supreme Court. But I wouldn't rely on that for contract drafting, and I wouldn't rely on any kind of waiver. So here's Aaron's question. Do we think that having a somewhat more difficult contractual path to avoid the effects of the reservation or declaration, whichever it is, appointing local agents as an opt-out, will decrease the number of parties who seek to avoid the service convention and or decrease the possibility of giving offense to another sovereign? Anybody on the panel want to address that?
Ron, I think Aaron makes a good point. I don't like the language of opting out or writing around. I think that Schlank was clear. Rockefeller Technology was correctly decided under Schlank. And I don't think we're going to find the United States Supreme Court backing off of Schlunk. That said, you're right about the sovereign concerns of other nations, and using an agent in the United States, as Schlunk did, seems to me to be a way to avoid it. On the other hand, when the courts say you want to give actual notice, that's what we're trying to do here, boys and girls, then I think it becomes sensible to provide courier service, email notification, so that you're assured that the agent who got the process does what he's supposed to do, which is sends it back home to his parent company. So my point is, if you care about actual notice, then you oughtn't object to means of providing actual notice when the means of formal, technically required service is under an agreement that doesn't involve any transmission abroad.
I might follow up on that a little bit. In both the 2005 Hague Choice of Court Convention and the 2019 Judgments Convention, there is language that allows denial of recognition of a judgment when there was not proper notice, and that's the US test. Was there real notice? But there's language that also allows denial when service was not consistent with local rules, which really ties it back to the Hague Service Convention and does acknowledge what in most of the world is this sovereign aspect of service of process. But I'm wondering, Professor Huang and Professor Zhang, what if Rockefeller tried to just take the arbitral award for recognition and enforcement? Doesn't the service question simply evaporate?
I would say the service is not an issue under the Hague, under the New York Convention, New York Arbitration Convention. I think there is a good prospect that the arbitration award can be recognized and enforced in China. How about you, Wenya?
I agree with you. Actually, I have been wondering why the Rockefeller did not seek the recognition of the arbitral award in China or in other places. So instead of just confirming the arbitral award in the United States. So
let me try to answer that question in one sentence, Professor Zhang. There were many aspects of the arbitral award that were quite controversial. Ron went by it quickly, but reasonable people could look at a $400 million award in a default proceeding and ask the question, where did the number come from? And there were lots of other such issues. So that I think that it would have been fair to say, had you taken the award to China directly, you would have expected a pretty hefty litigation over whether or not there were other reasons not to enforce it.
Okay, thank you.
Peter, and I just want to follow up on the issue regarding assessment. So because today I just taught English case, Adam versus Cape Industry. It is not an arbitration award. It's a judgment, but the issue is no independent judicial assessment in the U.S. default proceeding, and the case was decided by tax court, Adam versus Cape Industry, for recognition enforcement in UK. So the issue is the violation of the nature justice. But the issue is if it is an arbitration award, it should be recognized and enforced under the New York Convention. And the New York Convention has a very narrow ground for rejection.
I completely agree with you, Gene. My point, though, is even though the grounds are very narrow, if you look at this award, and I am not saying there's anything wrong with it, I'm just saying that if you looked at it as a litigant acting or a lawyer acting for Sinotype, you would say, even under that narrow ground, I can find reasons why this award should not be enforced. And I think that that may answer the question Professor Zhang asked, Namely, why didn't they go right to China with the award? And I think there's a $400 million answer to that question.
Yes, thank you.
Okay, I just want to end then. So far as the arbitral award is concerned, the party's choice of the service by mail is really acceptable in China. Okay, and the arbitration rules of Xitang or Beijing Arbitration Center all put this kind of service by mail in their arbitration rules. This is really acceptable in the field of arbitration.
So the answer there is, if you want to avoid the Hague Service Convention, use arbitration.
No, no,
Well,
I mean in arbitration, not in Hague Service in litigation. Okay.
Well, and there's one other thing I'd like to ask Katerina about this. The reason why parties write provisions of the kind I've proposed is they all think that if they go through the central authority, it will be forever and a day until their papers are served. If I were sitting in China and wanted to avoid having my sovereignty violated, I would say, look, if you send your papers here under the Service Convention, they will be served in general within 30 or 60 days, okay? If you publicize that and promise that, I can assure you there would be many more parties that would not try to do what my proposed agreement would do. But it is not just China that we're talking about here. There are many, many other countries whose central authorities refuse to expeditiously serve papers on powerful commercial interests in their country for litigation coming out of my country and others. And so my answer is, Katerina, can we get the central authorities to agree to perform in a agreed period of time that will cause parties to say, oh, they're doing their job and they're doing it well?
Oh, well, I definitely can't make a promise on behalf of the rest of the 70-some contracting states. But this is a really good point, and one I obviously ended on as well and spoke about, which is, the Hague Service Convention does perform a very critical function. For the benefit of going through, for example, the U.S. Central Authority and our designated contractor is you have 50 states. It's not, you don't have to worry about, serving in compliance with a particular state's law. That's our responsibility. You send a request for service to the U.S. Central Authority pursuant to the Hague Service Convention. It's our responsibility to serve it in accordance with state law. It's our responsibility to complete the proof of service. And we do that, I would like to say, quickly and efficiently. Our time frame is within 6 weeks. Of course, there are exceptions. So, we certainly would hope the reciprocal would be true for any other country. Peter, as you know, there are countries that assert an Article 13 objection based on sovereignty and security, based on the kinds of requests that you noted, and there's little to be done, as far as recourse after a contracting state or central authority asserts an Article 13 objection based on the Hague Service Convention. There are obviously things you can look into doing afterwards. But I do think, as one of probably the most widely used instruments under the Hague Conference, it performs a very critical function. But I think this Hague Service Convention, and again, as much as the conversation here has focused on contracting around it or waiving it or opting out of it, it could also work well, and it does, I think, work well in quite a bit of countries. I think the statistics show that, for the majority of countries and contracting states, requests for service are served quickly and effectively. I get a lot of calls from U.S. litigants who ask me, how do you affect service in Brazil? How do you affect service in Germany? And how do you affect, and they don't have the means or the ability to hire local counsel, but they don't have to. They can serve through the central authority and know that their request for service will be served in compliance with that country's laws. So again, I absolutely agree with you. I think it is in everybody's best interest, and certainly a contracting state's best interest to make sure that its central authorities are performing the work that they should be performing in a quick and efficient manner.
Katerina, because you've mentioned South America, let me just remind everyone, under the Inter-American Convention, if I recall correctly, the service has to go to you first and then goes to the foreign country. When we negotiated that agreement, the Latin American countries very much insisted on that, so that if you're using the, and many of the Latin American countries are parties to both conventions. So anybody who's got a service issue involving Latin America needs to think about which convention are they using, and if they're using the Inter-American Convention, you got to send it to Katerina first.
Yes, it does. So outgoing requests for service, thank you, Peter, pursuant to the Inter-American Convention are first sent to our designated contractor. I have to say, one of the things I've really focused on the last couple of years has been updating all of the information online. So in terms of the my office's website, so if you are interested, the Office of International Judicial Assistance, Department of Justice, if you were to search, we have a host of both evidence and service related guidance that we have published on our website. We have updated our contractor that I've referred to as ABC Legal. Their entire website has been rewritten with accurate and up-to-date information and frequently asked questions. And our practical information pages for both the Hague Evidence Convention and Hague Service Convention have been updated. So for any questions, I urge you to look at these websites, as I hope the information there is much more comprehensive and accurate than before.
Okay, we do have another question, but we've already gone almost 10 minutes beyond our scheduled time. And I think that the discussion has been incredibly interesting. The audience has stayed with us for it, and so that's the good sign. I want to thank all four of the panelists for a really high-level discussion of a ground-level issue that I think is quite important. I think it also sets the stage for tomorrow's panel session, which is the competition for dispute resolution services. Before you decide how you're going to serve process and you draft that clause, you have to decide where do you want to go. Do you want to go to arbitration? And this whole concept of new international commercial courts that's arising, it creates issues. It brings Hong Kong into the picture. We're going to bring Singapore into the picture. We're going to look at that broadly. And I invite you all to join us again tomorrow at 8 a.m. Eastern Daylight Time when we pick up the question at that point, and I hope continue this process of discussion that's important in not only U.S.-China relations, but dispute resolution generally on a global basis. So once again, thank you to our panelists. Thank you to those who have joined us. Please come back again tomorrow and let's continue the discussion.
Thank you, Ron.
Thank you.
Thank you. Thank you. Bye-bye.
Thank you.
Thank you, everyone.